Greetings to everyone, friends. This is just terrible. The Verkhovna Rada in Ukraine is currently urgently passing a bill, or rather a new civil code, which includes a lot of very bad things. First and foremost, for Ukrainians living abroad, and of course for everyone living in Ukraine, we will now go over the main 10 changes that will definitely have an impact on the lives of Ukrainians. Among them, for example, is raider seizure of your property, meaning that in fact your private property can simply be stolen, and you won't be able to protect yourself from this in any way. Second, this is a scenario related to freedom of speech, because the new civil code strictly limits freedom of speech and helps corrupt officials feel right at home and be protected by the law. And combined with our ineffective judicial system, a bought and paid for judicial system, I would even say, in many cases, this will simply expand the boundaries of corruption, which are already large, and will become even bigger. And many other changes. Let's talk about everything. Subscribe, leave a like, watch the video until the end. Thank you to each of you. Also, write in the comments which city you are watching from. And let's start with the first, the most important, the most interesting for Ukrainians abroad. This is the problem of private property, which now can be taken away from you just like that. First of all, the register becomes the main proof of ownership. The records are almost indisputable. This is Book 9, Publicity of Civil Rights. The project introduces a presumption that people know the information in the registry and significantly changes the logic. Позовної давності. The moment an entry is made in the register is effectively treated as the moment you became aware of a possible violation of your rights. Someone could illegally rewrite or change, let's say, the data in the register for your apartment, your house in the village, or your land share. And the time limit for challenging it starts running from the day the entry is made, not from the day you actually find out about it. Tell me, please, how often do you check the register and verify the information about your private property? Probably about as often as I do, which is roughly 0 times a year, and this will be a huge problem, especially for those Ukrainians who live abroad, who in fact have no access to these registers, and most people don't even know where to find this information. And now you could be living abroad. Someone could transfer your house to a third party, and there would be nothing you could do about it. One day, for example, you return to Ukraine and find your house is no longer yours, with completely different people living there. And the fact that you have some certificates or notarized powers of attorney, sales contracts, you might as well use them to start a fire, because now they mean absolutely nothing. And there's even a specific scenario for an ordinary Ukrainian, which I have also described. For example, a situation that concerns a huge number of Ukrainians who live abroad and who have already been living abroad for a long time. For example, you have a plot of land or a house that you inherited from your parents, for instance, in 1995. You have the documents in your possession, the originals, but this information was entered into the modern registry with an error, for example, in the coordinates, or it hasn't been updated at all, because you haven't dealt with it. You never submitted any updates, because you have the original documents in your possession and there are no problems. Fraudsters, through any corrupt registrar, register this plot, for example, in their own name. And you, for example, find out about this, go to court, show the originals of your documents. The court cancels this fraudulent entry. The deadlines are not fatal because you might not have known about it. That's how it used to be. Now, from the day of the fraudulent entry, 3 years are counted, not from the moment you found out about it, but specifically from the day the change was made in the registry. And if during this time the fraudster sold the plot to a third party who didn't know, not even hypothetically, about this problem, and you never find out about it, because it's basically impossible to prove, then the new owner is protected. That means someone could have transferred your apartment to themselves, sold it to their accomplice, for example, a third party, and that's it. The apartment is obtained absolutely for free, and you're left with nothing. And basically, in that case, you are left without an apartment or without land and without any compensation. And there's absolutely nothing you can do about it. And a very interesting point is that the Deputy Minister of Justice emphasized that the most controversial part remains the ninth book, Public Registration of Civil Rights. The Ministry of Justice previously advised removing it entirely from the draft, but for some reason, our chairman of the Verkhovna Rada, Stefanchuk, is defending it, and it is especially dear to him. It's this ninth book that actually deprives you of the protection of your private property. So that's basically how the story goes. It's actually very telling. And that's what I was talking about a year or two ago, that some steps would be taken. And we see these are very small steps, almost unnoticeable, towards depriving Ukrainians living abroad through fines, through such draft laws, through new codes that someone really needed during the war. Not during peacetime, but specifically during the war. And the work continues to take away all private property from Ukrainians living abroad. And to do the same with Ukrainians still in Ukraine. That's the first thing. Second, even if you decide to talk about it somewhere, you won't have that right. Because the next restriction is a restriction for investigative journalists and basically for bloggers too, for all people who talk about any problems publicly. So there's Book 2, Personal Rights. And it says there that the proposed version of Book 2 continues to undermine the fragile balance between the presumption of innocence and public interest. Personal rights and freedom of speech. The provision remains that gives people mentioned in reports the right to submit a response to any mention of themselves if they believe their personal rights have been violated, even without proving the fact of such a violation. So what happens? For example, if you wanted to, let's say you saw or conducted your own investigation about, for instance, that Mindic stole $100 million, right? There you go. You have some evidence. For example, you are Bihus.info or some other agency that conducts various types of investigations, Ukrainska Pravda and so on. And this causes public outcry. Mindic, under the new civil code, can go to court, file a complaint against you, and you will have to compensate him for moral damages and will be forced to retract everything you wrote until there is a court decision. And we see that court decisions here can take years to be made. Until there is a court decision, you have no right, absolutely no right to write about this publicly. What is this, if not a harsh restriction of freedom of speech? And even, if you think about it, even NABU, who conduct investigations and publish information publicly so that it gains public resonance, will not be able to do this. Because lawsuits could be filed against them immediately, and these cases will be very important and easily won by various corrupt officials. Actually, there are three main mechanisms. This is a very important point. The first mechanism is the right of reply without having to prove a violation. That is, if you publish some materials about someone, you don't even need to prove that you violated anything. A person can simply say, I don't want you to write about me, even if they're a member of parliament or a corrupt official stealing from Ukraine, and so on. And even if there are confirmed facts from the relevant law enforcement agencies that are conducting these investigations. The text still contains a provision that gives the subjects of a journalistic piece the right to submit responses to any mention of themselves if they believe their personal rights have been violated. What does this mean in practice? Currently, in order to demand a retraction or a response, you have to prove that the information is false or that your rights have actually been violated. Under the new provision, it's enough to have a subjective feeling that your personal rights have been violated. That means you can write this about anyone and anything. And in fact, you already have a legal basis for a lawsuit. That means officials, an official for example, about whom an investigation into corruption has been published, can file a lawsuit simply because they disagree with how they are portrayed. And even if all the facts are confirmed, it doesn't refute anything. The journalist is forced to go to court, spend time and money on defense, and the material is de facto frozen or removed from the public space. That's the kind of total protection our corrupt officials have. That's the first mechanism, and there are three of them. Let's break it down, moving on to the second one, vague criteria for moral damage. And in fact, this is a tool for putting pressure on anyone, bloggers, journalists, and so on everyone the corrupt officials don't like. Because of the vague criteria, lawsuits for the protection of honor, dignity, and compensation for moral damage can be used as a tool to pressure journalists, activists, and public figures. And when the criteria for determining moral damage become vague, it opens up the possibility for abuse and for using the courts as a tool to pressure these very investigators. So what does this mean in practice? A corrupt official files a lawsuit against a journalist not to win, but simply to get rid of him. The case drags on for years. The journalist spends resources on lawyers. The editorial office faces reputational pressure. And even if the court eventually rejects the claim, the goal is achieved. Because next time, the journalist will think twice about whether he should publish an investigation about this or that corrupt official. And if he publishes something about someone else, again, there will be court expenses, time wasted, and pressure on any editorial office. In fact, these are lawsuits filed solely for the purpose of intimidation. And this is what they now want to regulate here. Next, the third mechanism concerns the previous draft law, 14,057. It was directly called the destruction of tools for controlling such corrupt officials. And this draft law, number 15,150, includes a partial revision of draft law, number 14,057, which concerned Book 2 of the Civil Code, which strengthened the framework of personal rights and the means of their protection. Media lawyers, together with MPs, developed amendments to draft law 14,057, and although many corrections were agreed upon, some of the provisions proposed by media lawyers were not included in the text of 15,150. In fact, the entire Ukrainian community, all public organizations and so on, worked for many months on the changes to make this happen, to ensure it had balance. And in the end, these agreed changes were simply not included, let's say, in the new draft law. A typical betrayal of the Ukrainian people happened. Actually, this is the next thing. This is the destruction, as we can see, of rights. On one hand, it's the destruction of freedom of speech. On the other hand, it's total protection of the personal rights of the corrupt officials. At the same time, all of this is happening under the official narrative of strengthening personal boundaries and personal rights. This is happening against the backdrop of total bussification, when people are being rounded up on the streets like dogs and sent to the front. And for those who want to go abroad, the border is closed to them. Because we see that civil rights here are only for the corrupt and only for those who have access to money and to power. And please tell me, write directly in the comments, do you think it's possible to build any kind of future in a country with such a civil code and such changes during wartime? Because, as I see it, all of this is simply leading Ukraine to its total and complete destruction. Through these kinds of small steps. Next, moving on. A term called propriety is being introduced. This is a vague legal filter under Article 6. It is defined as a set of moral norms and principles, standards of ethical behavior, and generally accepted ideas about proper conduct. And if actions contradict this concept, legal consequences follow. There are more than 40 mentions of this same concept of decency in the code, and there is no interpretation of it at all, no detailed explanation whatsoever. That is, all there is are just some generally accepted moral norms that are not defined by anyone. Nothing is written down anywhere. That is, there is a complete and total lack of legal certainty, which is required by the Constitution of Ukraine. And our greedy deputies have already voted for this in the first reading, by the way. Next. Who should decide what is moral and what is immoral? A specific judge. Can a judge be bribed? Yes, he can. And a judge can interpret your behavior and your actions as he wishes, through his own personal lens, and not through the lens of the law. This is a very important point, because courts will be able to make decisions left and right as they wish, ignoring the laws. This concept of decency applies to agreements, family disputes, and even business relations, and not just to the fact that you quarreled with someone. That's it. We'll come back to this in a moment, because now even in Ukraine, discrimination will be allowed due to your lack of integrity. So, if you do something not the way the judge wants or not the way the judge thinks is normal, then you're basically a criminal, and you can even be discriminated against, but we'll get to that later. Fourth point. The court can reconcile spouses instead of granting a divorce. This is stated in the 6th book of family law. For reasons of decency, the court is given the right to reconcile spouses. Who wants to get a divorce? So the judge can delay the divorce, deciding that it goes against morality. More hearings, more expenses, less actual control a person has over their own life. So, in this case, the court won't be an instrument to solve your problems, but instead the court will decide what is actually a problem for you and what you just made up in your head. And after this point, there will be a very interesting aspect concerning, for example, family violence and domestic violence. Because now, in fact, the one who has more money has more influence. They can use legal mechanisms to not let their partner go, bribe judges, and the victim won't even be protected by the law. So this is a complete mess. Next, fifth. Reduction of the alimony collection period from 10 years. This is also in Book 6. Currently, the law allows for the forced collection of alimony for the past 10 years through the court if a person does not pay this alimony voluntarily. In the text of the draft law, this period is reduced to 1 year. The reason for such a change is completely unknown. But in fact, those who stay with their children because the other partner, let's say, leaves the family, this person is no longer protected in any way. Just imagine, 1 year. Out of 10 years, you will only be able to recover alimony for 1 year. And tell me, please, will this encourage people to pay alimony? Because it seems to me that it absolutely will not. In fact, what we see here is a reduction of the child's rights and protection. Is that right? Наступне. Next, an ex-husband or ex-wife can demand to change the surname after divorce. In case of divorce, a man or a woman, if their spouse took their surname, can demand that their ex-partner change it back to their premarital surname. For example, in cases of immoral behavior, infidelity, or similar situations, who determines what is considered immoral behavior? That's right, this is also determined solely by the judge. Next, another interesting point is discrimination. Discrimination is allowed for the protection of public morals. Here, Article 6, Book 1. The Code prohibits discrimination on specified grounds. But there's a clause stating that discrimination is allowed in certain cases if it's necessary for the protection of public morals. The anti-discrimination provision essentially cancels itself out because of an exception without clear boundaries. Because no one really knows what public morals are, even though they're mentioned 40 times in the Civil Code. Overall, this Civil Code seems to me like some kind of mockery of the Constitution, of Ukrainian legislation, and of the law in general. And I get the feeling that Ukraine is just a testing ground to see how long people can put up with this nonsense. And to what extent people can be fed lies. Next, 60,000 forest and coastal landmarks remain without legal protection. Book 9. According to the Ministry of Culture, there are over 65,000 archaeological sites in Ukraine, but only 5,000 are recorded in the cadastre. The rest are legally vulnerable because these lands are listed in the cadastre as agricultural or for development. A buyer can simply claim in court that the site was not in the register, so he acted in good faith, and he will win the case. And now it will be impossible to return this property to the state. And what will happen? That's right, massive corruption. That 60,000 archaeological sites, forests, and coastlines in Ukraine can be plundered for pennies simply because of corruption. And corruption here is rampant. And what is being adopted now completely removes all restrictions from the corrupt officials and criminals. Next, unclear boundaries of public property. Risk of privatization of strategic assets. This is mentioned in Book 9. If the state, for one reason or another, forgets to classify a certain strategic asset as public property, it automatically becomes something that can be acquired as private property. The new project lacks a clear definition and criteria for public property and does not set proper protection regimes. Supreme Court Judge Crad directly stated that even the Black Sea coastline has already been transferred into private hands, and the new code legalizes this. In fact, everything that can be stolen in Ukraine will be stolen. For me personally, I don't understand why we should defend Ukraine with such a civil code. Because while the armed forces of Ukraine are laying down their lives at the front, we see that in the rear, everything is being arranged at the fastest possible pace. Next, friends, is the de facto family union. It can only and exclusively be between a man and a woman. This is stated in Article 1474 de facto family union. A de facto family union is defined exclusively as the cohabitation of two persons of the opposite sex as one family without marriage registration. If you are a same-sex couple and consider yourselves a family, the law does not recognize your existence. This means there is no protection of joint property, inheritance, or medical decisions for such couples. This is another point, a very small one, but let's be honest, it's important for a certain number of Ukrainians, both abroad and in Ukraine. These are the 10 changes and what awaits us next. First of all, on April 28, 2026, the Rada adopted the draft in the first reading. 254 voted in favor, 2 against, 5 abstained, and 45 did not vote at all. So what awaits us next? There should be further work done in the committee. The Committee on Legal Policy gathers amendments from deputies, ministries, and the public, and there are no time limits. This can take months, or it can happen very quickly. The second reading in the Rada is a vote on specific articles with amendments. This is where the final text is determined and a majority is needed, namely 226 votes. But if this nonsense was voted for in the first reading and there were 254 votes in favor, then in the second reading, 226 votes will definitely be secured. Next, it is signed by the chairman of the Verkhovna Rada, then by the president, and actually everything comes into force. And now is the best time to put pressure on the deputies. This is called public pressure. And here it's very important not to stay silent and to talk about this civil code. Because if this civil code is adopted, then your income, private property will be at risk, freedom of speech will be at risk, family ties and family life will be at risk, and many other things will be at risk too. I've only covered the main 10 points here, but in reality there are many more. Some are smaller, more minor, or maybe I missed something. The code is 800 pages long, and there are a lot of hidden pitfalls that we don't know about yet, because we haven't gotten to the most important parts. I only took what personally resonates with me the most. That's why it's absolutely essential, very important to share this video, to share other similar videos. It's necessary to record such videos. It's important not to stay silent so that this draws public attention. Because without this, there will be no future for Ukraine or for each individual Ukrainian. People who are abroad but have something in Ukraine can be deprived of it like this because of some scammers, of whom unfortunately there are very, very many in Ukraine today. What do you think about this? Write your thoughts. It will be very interesting to read your opinion. I wish everyone a good day. See you.